Good evening to all of you. Welcome to Legal Matters by Sai Baba Sunkara. అందరికీ శుభ సాయంత్రం. ఈ వీడియోలో ప్రైవేట్ కంప్లైంట్ తీసుకోవడానికి గురించి సుప్రీంకోర్టు వచ్చిన జడ్జిమెంట్ గురించి చూద్దాం. The magistrate should act judicially but not mechanically while taking a private complaint on file. This is the important point in this particular case. In the case of Prakash Ambedkar versus the state of Maharashtra and others, criminal appeal number 352 by 2020, decided on 16/1/2025. In this case, Honorable two judges bench, Justice J.B. Pardiwala and R. Mahadevan, held that magistrate can direct the police to register the private complaint only when there is necessity for investigation or necessity of the IO is there, and when the court thinks that the cause of justice can be suffered if there is no investigation. కాబట్టి ఇన్వెస్టిగేషన్ నెససరీ అయినప్పుడు మాత్రమే ఇన్వెస్టిగేషన్ ఆర్డర్ చేయాలి. అదర్వైజ్ ఏం చేయాలి? డైరెక్ట్గా తీసుకుని సీసీ నెంబర్ ఇచ్చి హీ హ్యాస్ టు కండక్ట్ ద ట్రయల్ ఇన్ ద కేస్. దట్ ఈస్ ఫస్ట్ టు బి డన్. బట్ ఇన్ ప్రాక్టీస్ 156 క్లాస్ 3 కింద మ్యాజిస్ట్రేట్ గారు ప్రైవేట్ కంప్లైంట్ రాగానే పోలీస్ అధికారులకు చేస్తారు. 3 ఏళ్ళ టైం గడిచిపోతుంది. Now coming to the facts of the case, actually this is an assault on an advocate. His name is Devidas Kubade. Devidas Kubade anayana, his allegation is that he was intimidated, with abusive words by the police on the night of 31/12/2011. కారణం మీకు అర్థమైంది. At 11:30 p.m. he was humiliated by the police. He was actually literally intimidated by the police. He went to the police station. He wanted to lodge a report. He has drafted the complaint, but there is nobody to receive the complaint. No action. He approached the Bar Association and represented the matter. The Bar Association advised him to go to the Superintendent of Police, Yavatmal, YAVATM, Yavatmal. Likewise, so according to the directions, he went to the Superintendent of Police, and same is the case. So you may be knowing under 154 class 3 crpc, if no FIR registered, you have to approach the Superintendent of Police, who will direct some other person to investigate the case. But that was also not done. There's a case when there is no other go for him, he filed the private complaint under sections 323, 294, 504 and 506 of the Indian Penal Code. 323 is causing simple hurt. 294 is that is called as obscene act. That means by using the so-called obscene words. 504 and 506 they intimidate, criminal intimidation and threatening, all these things. Right. So when he filed the complaint before the magistrate ordered FIR to be registered without inquiring into the matter. So therefore, after they registered the FIR, the other side, that is Inspector Prakash Ambedkar, they have come. Some of the accused, they have filed the appeal before the Supreme Court. The matter came out to the level of the Supreme Court to quash the FIR. Here the important points to be considered by the court are, number one, the case is relating to 2012. Of course, 31/12/2011 means almost you can say it as 2012. Then, magistrate is expected to delve into the sections of law. 294 is obscene act in the public place. Mere using abusive words, mere using unparliamentary language doesn't come under 294. No. Likewise, section 506 is also not applicable as per the contents of the draft or contents of private complaint. In such a case, Where is the necessity to register a case and investigate? Absolutely, there is no necessity. The magistrate mechanically endorses the matter to the police for investigation, which is not correct. Luckily, in the present, the CRPC is converted or from 1/7/2024, the so-called Bharatiya Nagarik Suraksha Samhita section 175 has come into existence. In that, the principle of adi alteram partem is taken into consideration. Whenever any private complaint is filed, the magistrate has to inquire, the magistrate has to call the other party, they have to seek the explanation from the other party, then only he has to direct the police to reach the case. So please remember, before ordering investigation, the magistrate has to act judicially but not mechanically. An important case law, that is Priyanka Srivastava versus State of UP 2015, was cited in this connection and the FIR was quashed. Good decision by the Honorable Supreme Court of India. Read it and enrich your legal knowledge. Thank you.